Good afternoon once again, and here we are on day 2 of our FTP session. Of course, before we begin the session, we have a few instructions. Kindly mute your microphones and do switch off your videos for better quality. You can raise your queries in the chat box, and participants who are watching the live streaming can post your queries in the WhatsApp groups. The moderator will take your questions up to the speaker. An investment in knowledge pays the best interest was one of the quotes by Benjamin Franklin. A very good afternoon and a warm welcome to day 2 of our FDP, Integrated Learning and the NEP 2020, organized by the IQAC of our college. We deem it a pleasure to have such eminent people in our midst for the sessions. A special note of welcome to our speakers, Mr. Vivek and Mr. Nagarjun, who have humbly accepted our invitation to be here with us this afternoon. Once again, on behalf of St. Francis de Sales College, we render a cordial welcome to everyone. As we begin, let us submit everything into the hands of the Almighty as we say our prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Amen. We now move on in our journey of learning, and in doing so, we are extremely happy to have with us Mr. Vivek. Mr. Vivek is the consultant and IPR attorney, Patent Information Center, Karnataka State Council for Science and Technology, IISC Campus, Bangalore. Sir was introduced to us yesterday as he gave a holistic overview of intellectual property rights. We are glad to have Sir with us today as well for our session. We welcome Mr. Vivek to our session, day 2 of our FTP. The session over to you, sir.
A very good afternoon to one and all present in this particular session. Once again, I would like to thank the principal and the coordinator for this successfully organizing the second day of the program. And I could see some of the messages stating that nice to see you once again, Mr. Vivek sir. Looking forward for another informative and valuable session is what I have already got. This message is a kind of an instruction to me that I need to keep up to the mark provided by them, right? Yes, I'll do that. And yesterday, as the concept which is already been provided, copyright, and using it as an effective tool for the researchers is what, or an academicians or students. So that's what the perspective we are going to take up today, right? I would like to, as you all know that my session, like my session will be like a discussion with you people, and that's how I wanted to take it forward. May I quickly ask a particular question to you all? First one is, sir and madam, you all have written various articles. Nagarjun. You must have all written various articles. which has been got published in various journals. You must have given your articles for conferences. You must have submitted your articles for journal publication or e-journal or things likewise. In that context, here we have a subject called as copyright. What is copyright? Copyright is the person who writes an article, a person who writes a drawing, a person who creates some artistic work has a right to replicate or make copies of it. So he has right to copy, right? So these are all the rights which you have at this point of time. And the question is that copyright is a bundle of rights. What do you mean by bundle of rights? It has many rights within it, such as right to issue copies, distribute copies, translate the copies, transform the copy of the work into a movie. A bundle of rights, not group of rights, a bundle of rights. Unlike patent is only one right, that is right to exclude. Patent is a negative right which says right to exclude others from making, using, selling, offering for sale is what it has been clearly told. But in copyright, that's not so. Copyright is a bundle of rights. Bundle means it has more than hundreds of copyrights in it. Okay. So now, in such circumstances, we have some scientific community, we have arts, we have commerce people. So all these faculties or research scholars may write an article on, if a scientific biotechnology background people, where they are writing an article on extraction of oil from a neem seed. That's an article which they have written. At the same time, we have the arts people telling about, the arts background people telling about various, a comparative study, okay, about comparative study about how plague or other diseases which occurred, or a pandemic situation occurred at the various circumstances in India, and the present pandemic. It's comparative study, it's evaluative study, it's analytical study. You have written this kind of an article. Now the article you have written. Now the question is, you must have all given your article for various journals, publishers, etc., etc. When you give this thing to them, they publish your article. At the same time, whenever you wanted to search for some articles in the internet, whenever you wanted to download some important books or articles, it usually asks for so and so price to be paid for a download, right? If you want to download that article, you need to pay for it. You must have seen this kind of situation. Now, there can be a circumstance where our own faculties who have written those articles, which has been now converted into a payable mode, and if someone wants to download, they have to pay for it. Or your articles have been joined a pool of articles has been joined for some e-journal, or where any institution or any person who wanted to use those articles, they have to subscribe for it on payment of your annual fees, etc., etc., etc. So there is a cost which comes with those articles, right? Now my question is, sir, your own articles you have given for publication, it has been published, and if someone wants to access it, there is a cost on those articles. Your one article which has been published in the various e-journals, that they have been taken, and now if anyone want to subscribe that particular journal, they need to pay for it. Now the question is, you people have written those articles, but did you get any royalty for those articles? The first question is, Did you people get any royalty for the articles published? Yes. Answers, please. Did you get or not? Yes or no? Mamta madam? Anusha ma'am? Mukesh sir? Aruna BN? Yes. And where is our Manjunath sir? Okay. No one, everyone says they have not received any royalties for the subscription or download of so and so article, etc., right? Okay, fine. Everyone said no. Did not even a single person get any royalty? Rakesh Swami sir did not receive. Fatima madam did not receive. Yes. Amitabh sir. Mr. Sir, what about you? Did anyone receive any royalty? Okay, are you okay? Fine. Okay, everyone says I have not received royalty. But do you feel you are entitled for royalty? Does anyone feel, yes, sir, I feel I should receive royalty for my work because it has been commercialized, because it has been downloaded by many people? Okay, at least there you must have your article is being downloaded by some 50 people. Okay, 50 people have shared your knowledge, right? They have understood about the circumstance, right? Isn't it at least some amount should come for those download? Today you upload a video to a YouTube, and if there is some few thousands of views, and you get money out of it because it has been advertised, and there is a money collected by the YouTube. At the same time, these publishers whom you submit your article, for anyone to download those articles or refer those articles, they have to pay as a subscription fees, an annual subscription or whatever subscription kind of thing. And they are getting, what do you say? They are getting money. But did you get any royalty? Isn't it you are entitled for such royalty? At least when there is you must have seen in Scopus indexing or H indexing, where there is how many people have given references for your article. The more the reference, the weightage is more. Don't you think that for such a reference of your material or idea of your thing which you have written, if someone has used it, don't you think that you should also be given some amount of royalty? Yes or no? Do you feel you need to get royalty or not? Yes or no? How many of them feel that, yes, sir, I am entitled for royalty? Yes. Balchandra sir always in the first to say. What about others? Only one? Chaitra madam says 2. Among 140 people, only 5 people, 4 people. Rashmi madam. Meherunisa. Okay. Pratik, Rajendra, Monica, Rashmi madam, Shilpa madam, Arun. Okay. That's among 150, among 140 people, 15 people says that is approximately 10% of people are only interested to get the royalty. Sir, yes, but we feel the copyright form. Lakshmi madam has raised Lakshmi madam says, sir, of course, we are entitled for royalty, but we have filled a copyright form. What copyright form you have filled, madam? Yes, sir. Amitabh, sir, what is that you have done? Of course, you are entitled for royalty. You all agree for it. But will you get it?
Hello.
Yes, go ahead, madam.
Sir, no, we won't be able to get it because nowadays, whenever we write any chapter for any book also, there's a copyright that we need to give them the authority for regarding all these things to the publisher or to the person who is being publishing the book. So how we are going to get the royalty about it?
Okay, wonderful. Madam, that's a wonderful question you have asked. I would like to tell one situation which I came across. In the year 2016, we did a conference when I was at National Law School of India University on standard essential patents, where we had called for application for paper presentation and the same to be published in a form of book. Okay. When this happened, we had a condition in our form of submission of application stating that once you submit your application, all the rights in the work shall belongs to the publisher. All the rights in the said work shall be transferred. Is what a particular statement would have been there, and you should have said yes and put your signature, consent for it. So that means you say, sir, because I have already transferred my right to the publisher and there is a form which says that I have to transfer it, hence I have transferred, hence I have no right to claim for royalties, what Amrita madam says, right? Everyone says yes for this, right? But what is the way out? Okay, usually I used to say the answer, but I'm opening up the question to you all that what is the way out? How do we overcome this? How do I get the royalty for my work? Any options, madam? You have already transferred your copyright in the work at the time of submission of your article to them. Hence, I have lost my right, is what madam says. Right? Of course, I agree with you, madam. Or else, what are the other ways? Do we have any other ways? Yes. The question is for others also, please. Archana madam, Mr. Kausar, Prakash, sir, the academic coordinator, it says, Anita ma'am, and others, please. The question is, at the time of writing your article, you have transferred all your rights to them, and they are making money, they are making royalties out of your article which you have submitted, and you have not got anything, but you would wish to have it. But what is a way out? What is a way out? Lakshmi ma'am? Yes. Bhalachandra sir, get the copyright first and then publish the article. Bhalachandra sir, no. Dhruva sir says, royalty can be shared based on number of sales. Wonderful. Wonderful. Dhruv Kumar sir says, sir, will tell that, okay, after 500 copies or 50 copies or 100 copies, after 200 copies, if the said work is being published, we'll tell to the Amazon or whoever it is when they publish my work, saying that, okay, fine, this is what you have to give royalty to me. Okay, that is in the case of a book. But how about in an article? Yes, some more responses, please. Amrita ma'am. And number of views, wonderful. Dhruv Kumar sir has come out with a very good idea. He says, sir, number of views will, however, even in the any video you see in the YouTube, that also depends on number of clicks. How many number of people have clicked for the advertisement, or how many of it is not on the number of views or number on the person who have clicked on your article to view for it. You will charge on that basis. Yes, madam, go ahead. Amrita ma'am.
I have a question in this regard.
Please.
Everything cannot be justified by the fact that we will get the viewpoint regarding these clicks. Like regarding your chapter or something which you have published regarding a conference proceeding, or into some papers. Okay, I agree with the papers or articles, but otherwise you won't be able to get the information. No, how much clicks or how many views you are getting. How will I get to know that now after this point?
Wonderful, wonderful. No, madam, don't think that you will not be able to retrieve those data. Each and every click, each and every view, because every views or every click or everything has to be recorded. It will be recorded and it is been licensed out to you. This is a complete formula is available. the software is available to know how many clicks has happened.
Okay.
Okay. And the simple example is when you see YouTube, at the below there will be a number of various methods. That is, how many of them have given thumbs up, how many of them have shared, how many of them have viewed, etc., etc.
In case of YouTube, yes, but otherwise.
Yes, even for the article it is available. Yes. Absolutely available, madam. Don't worry at all. The software and the systems are already in place.
Authority to see that would not be available to me, no. The person who is
question.
Yes.
Wonderful question. There. Yes, I just wanted to hear this question. I'll answer it to you. But in the meantime, I wanted the response from the others also to participate and say their views. Okay. Here, Mr. Shiva Kumar sir has told, copyright with article helps me in getting views and it gives citations, correct? And my thoughts will get recognized. No duplication can be cited. Ideals, the copyright. Recognize and no duplication can be cited. Okay. Thought will get recognized. Okay. I all agree with your point. I all agree with Shivkumar sir. My question is, fine, people have shared, you have got views, you have got citations. That's all you require. If the publisher who publishes your article, if he does only for the people's view, etc., with no cost from anyone else, if he is also doing for a free purposes, then I agree with you. But what if the publisher or the person who is at the other side, who gives out this knowledge resource on a subscriptional basis, on a particular cost, aren't you entitled for certain such cost in such circumstances, apart from the citation, apart from the views, apart from the references? Is my question, is my suggestion to you. Now, I say, yes, we are entitled for it. And I was about to tell you a situation, what happened. In this particular conference, when we called for application, we have received various applications. In that, one application stated that I will not be able to transfer all my rights in the article to the conference proceeders or the institution. Rather, I will transfer only my right of publication of my article in the conference proceedings or in the conference book. Only. That means what? You see, he clearly categorized, narrowed down, and told, sir, if at all, if you want to accept my paper, you can accept my paper, and I will not be able to transfer my entire copyright, because copyright is a bundle of rights which has various rights in it. Hence, they said only a right to transfer, right to publish my article in that conference only. This is what he told. And this, and many of them say, sir, my article getting published in such a big journal itself is a great news. And what are you talking of royalty right now? I said, agreed. If that itself you can consider as a royalty. But at a particular stage, when you have reached into a particular situation, when the readers there is an increase, then many people will come back for your research and get to know what you have done and wanted to know about what you have done. In such circumstances, when they make money out of it, you should be entitled for royalty. And it is all possible. Even if there is a copyright form mentioned, you can tell to the publisher that, sir, I can give only my article if it is a conference proceedings, if it is so and so, see the velocity, see the journal who is publishing, see who is doing that. Depending on that, you can decide upon how you wanted to negotiate or bargain with your IP. Just merely because it is there in the form, you need not live, provided you feel that you are above that particular conference. I mean to say, you are going to meet, your research work is going to meet the requirement, and above you are standing at a better position. Only if it's a qualitative work, then you can ask for it, right? So our objective is, and I feel that your all work are having qualitative Hence, you should be entitled for copyrights. Right? Hence, you can surely ask the respective owner or author stating that, sir, after so-and-so views, after so-and-so publication, after so-and-so download, after so-and-so, you should be, I should be entitled for royalty, and you should share that, is what you can absolutely say. Right? So at the same time, we have some kind of a response from Mr. Gowda ji. Copyright is manually published and author intellectual property rights. Absolutely, sir, I agree. Okay, so now the whole question which came up was, sir, when I say I am transferring my right to someone else, means I should register my copyright. I should register my copyright. It's some authority, right, to get that copyright protection. Is it mandatory to register? For example, if I have a 30/40 site, if I'm transferring the rights to someone else, then I should have registered the copyright, right? But in India or in any other, most of the countries, wherein after various treaties and negotiations happening, it has been said that, or declared that, registration of copyright is not mandatory. There should not be any formalities to have a registration of copyright. But if you register it, it acts as a conclusive proof. So once copyright, what do you mean by this registration is not mandatory, and how will I, what is the proof of registration, etc.? If all that is your question, then here is an answer for you all. Now, I have told you how do we collect royalty, how do we do that royalty bargain with the publisher, stating that, sir, so and so things happens. You must have, in the form of books, there is such kind of a methodology for collection of royalty, etc., from the having a bargain with various publishers, stating that, yes, so and so is how many thousands of books are being sold, and above that you shall share me so and so amount, etc., etc. Right? Yes. Now let me with all these opened up various questions and doubts in your mind, let me put up my PPT. Just a minute. Mamta madam has put up some kind of a question. A clause of distribution of royalty has to be included in the form by the publisher, right, sir? I might write to them, but the form counts, right? Once signed, we loses our right. Yes, Mamta madam, if you have already signed and given the application to them, it is gone. Okay, it is gone. And this awareness program is to make you that you be ensured that don't simply sign and give it off because it is mentioned in the form. Okay, you still have all the option to say to the publisher or whoever the conference organizers that, sir, I will not be able to transfer my entire copyright to you. I'll be able to transfer 1, 2, 3 rights. That's all. In case of conference proceedings, or if it is a publisher, in case of a chapter or a book which you have written, then you can tell to the publisher, hey, publisher, come on, if you wanted to publish it, so and so publication copies, you can sell it out, and after such 3,000 copies of selling, you shall give me so and so number of copy. After 6,000 copies, you shall give me 40% of royalty. After 9,000 book, you shall give me the 40% of royalty, is what you can clearly settle and write down. Okay, so that means before you enter into any contract for transfer of your copyrights, ensure and see how effectively you are going to manage on this and going to get the royalty on it. Okay, so that's what you need to be very careful about, the clause and the condition. Very good. Thank you very much, Mamta ma'am. Now let me go to my PPT. Okay, now let us formally understand what is this copyright. How does this, what do you mean by copyright? What is the period of protection of copyright, types of copyright, all those things we'll understand. And types of right you have, what are the bundle of rights, as I said, that also we'll understand with some case study. Okay, Hope you are all able to follow the session.
Yes, sir.
Yes. Are you able to see the presentation?
It's loading,
Yes,
sir.
sir.
Yeah.
Yes,
Yes
yes.
or no?
We are able
Yes.
to see. We are able to
Yes,
see.
yes.
Wonderful, wonderful. Yes. So that's what. So after all these things, I have posed a lot of questions to you, and I think it has opened a very big questions in your mind. That yes, even if it is there in the forum, madam, don't worry. Write to them and say that, sir, sorry, I cannot transfer my all rights with you. I can only transfer so and so rights to you, or you can have a bargain. Okay, you can surely have a bargain with them. Yes, my now few questions to you I'm going to ask. Kindly keep your hands ready in the chat box and quickly start typing the answers, right? The question is, what do you see in my slide? Quickly you have to tell. And one more condition here is that you should not, what do you say? You should not repeat the answer which is already told by others. That's the primary condition. Yes, it's a painting, artwork, flowers, wonderful. You should not repeat a sketch, colors you should not repeat. Yes, then plant, art exhibition, lotus which is repeated, art is repeated, beautiful painting, water painting, wonderful, excellent, wonderful, wonderful. What about this? What do you find here? Next. Intellectual work, very good. Leaves, yellow color. Yes, next. What do you find here? Fish, modern art, splash of color, modern art of fish. Yes. Creativity, very good. That's what I'm looking for. So I'll take up intellectual output or a creativity or an art. Yes, these are all the correct answers. Yeah. What about this? What do you find here? Innovative art. Okay. Okay. Wonderful. Modern art. Wonderful. What do you find here? Abstract painting, birds, lake flowers, natural comprising art, attractive birds. Okay. Anything else? That's all. Illusion. Okay. Men and a women. Wonderful. Swan. Wonderful. Wonderful. A feeling. Very good. Just a minute. Hello. Madam ಹೇಳಿ. ಇದೀನಿ ಮೇಡಮ್, ಸೆಷನ್ ಅಲ್ಲಿ ಇದೀನಿ. 1 hour, ಇನ್ನೊಂದು ಅರ್ಧ ಗಂಟೆ. ಹೌದಾ? ಬರ್ತೀನಿ. ಎಸ್ ಯಾ. So very good. It's a feeling. It's a modern art, abstract men art, imagination, contemporary art. Very good. Wonderful. Sir, so far whatever you have said are all right answers. But correlating with this to our copyrights, I would like to say that it's a creative work. It's a modern art, but there is a lot of feeling in it. There is an expression in it. There is an expression of an idea expression, or an expression of an idea with respect to a man, a woman, a bird, color, etc. and etc. What is that which copyright protects here? What is that which copyright protects? Question is, what is that copyright protects? The idea? No, Archana madam. No. Madhu sir says expression. Balachandra sir says exactly the answer is what? Expression of an idea. Copyright protects not the idea. It protects not the creativity, not the picture, not the coercion, way it is represented. No. Author's right. What right? Artwork, no. Copyright protects what?
Expression of the idea.
Wonderful. Copyright protects the expression of idea, right? So, under the Copyright Act 1957, it is been specifically categorically stated that copyright protects only the expression of an idea and not the idea, because idea is as free as air. What is idea here? A man and a woman with a modern art. That is a basic idea, right? And this idea is as free as air, sir. Is as free as air. Anyone can draw person of a man and a woman. Can you stop others from who have taken an idea of a man and women in a village kind of thing? No, you cannot. Or consider Ramayana. So we have Ramayana where Rama, Lakshmana, Sita, where Sita was kidnapped, then Hanumanta came, he went and rescued, then they brought back, etc. This is a Ramayana book. It's an epic. Now, can you say, hey, come on, I have written Ramayana and this is my idea. No one else should copy. And you know, there are hundreds of Ramayana, Skanda Ramayana, Tulsi Ramayana, Sriman Ramayana Darshanam by Valmiki, etc. and etc. Right? So, it is only, so what about then these people who have written? These people who have written with their own expression, and the expression is protected in the copyright and not the idea. For example, today, the Faculty of Biotechnology has written an extraction of oil from a neem seed. Or a particular researcher has come out with a dryers, or what do you say, a study on vegetable dryers, right? So, and its process. This is what they have come out with. Now, when they have come out with this kind of a research, right, you have written an article on this with respect to an expression of an idea. In such circumstances, such expression of idea is only protected under copyright and not the idea per se. And idea is as free as air. Okay, it is as free as air. So, in that context, if you have written an article on vegetable dryers, then anyone can take up that particular methodology and study and do it. Who stops for it? Okay, now the question is, now you can find in my slide two pictures. One is The Dangerous Gishk and the other movie, a Bollywood movie. Can you tell me, was there any copyright from the Bollywood movie to the Hollywood movie? Yes. Matthew sir says, yes, there is a copy. Balachandra sir says, yes, copied. Prasanna sir says, yes, copied. Gayatri madam also says yes. Okay, next. What about this? A Hollywood flick Inception and a Bollywood film Badlapur. Though idea is as free as air, ideas differ in every individual right. Archana madam says, yes madam, it differs. Who said no? But the question is, how do you bifurcate when there is an infringement of some work, copy or not copy? What about this? A Portugal music album, which was there in 1973, and your Amir Khan's PK. Do you find anything which is copied? Yes or no, please, quickly. Suresh sir. Yes. Both are nice movie. Okay, what about this? Ravan and the Batman. Do you find anything which is copy? Shantraju sir says, no sir, there is no copyright infringement. Mamta madam says yes. Monica madam says yes, an idea. Achana madam says yes. Okay, what about this? Mausam and the Titanic. Mausam and the Titanic, what do you feel here? What about this? The Hiss and the King Arthur. What about this? The Aitras and the Graduate. Do you find anything which is copied here? Many people says yes. Jennifer madam says no. What about this? The Rowdy Rathod and the Replacement Killer. Inspiration. Oh my God. Dhruv Kumar sir says, sir, it is an inspiration, sir. We have only got inspired by that article. That's all. Sir, these movies clips might come under the category of inspiration. Copy. Madhu sir says copy. Dhruv sir says he's laughing. Okay, then. Okay, let me skip that. Yes. Sir, as I was telling you, everyone, you people were all in a decision mode to say whether there was a copyright copy, whether it amount to copy or it does not amount to copy. And some people also said that, sir, this is only an inspiration. I got inspired by that article. Hence, by the picture, hence I made like this. And it's not copy, sir. You all said, right? But we should understand that what is that which is copyright law says. What is that copyright law says? What is protected and what is not protected? So copyright protects creativity of an author, which is in the form of writing, articles, music composition, filmmaking, and copyright protects the work. And I have already told you, protection of copyright is only for the expression and not the idea. I was giving an example. What is the example? Example of vegetable dryers. What is this vegetable dryer example? Sir, now a particular, okay, let us see what is an article, how our article look like. Our article has a title, it has an abstract, it has a keywords, it has an introduction. After the introduction, there is a comparative study or a literature review, the methodology, the usefulness of the study. You would have stated. Then you would have told how dryers can help in preserving the vegetables for a long time, and how we can maintain this price fall when it happens, and dry it and put it into the powder form. And whenever there is a huge demand, we can leave those products. For example, tomato, okay, or an onion. Today we see the tomato which has been available for even 10 rupees or 5 rupees per kg, or when with the farmers per crate, okay, that is around 15 kg of tomato which they are been selling out for 100 rupees or 50 rupees. Sometimes the same one crate was amounting to 1000 rupees or 800 rupees. This was a price fluctuation. So in such circumstances, what is a methodology here one researcher do? He say, come on, sir, we'll dry our tomatoes when it's cheaper, especially in the rainy season, and keep it, preserve it when it in the powder form or other form. And whenever there is a demand, or whenever we can leave it in the packet form, whenever they want, they can, instead of cutting the tomato, they can put this powder and make it rasam or whatever soup or whatever they want, or for whatever dish they want, they can add it. So he has come out with an effective methodology. After the literature review, he see how other countries are doing or other places which are doing, and now he comes up with a new methodology, how effectively he can dry and preserve it. And he is successful, and he knows that earlier how people were using and they were having a lot of wastage, etc., and spoiling what happened. So he had come out with a new methodology, and he has got a wonderful result that yes, he can effectively make a huge amount of money out of that. And he has written a conclusion and end notes. Now this is what you have written, assuming. Okay, keep this example with you. I'll take you further. Yeah, sampling also you have done, comparison also you have done, everything you have told in your article. Okay, let us see what happened in this particular case. Yes. What was this case? This case was regarding R.J. Anand versus Deluxe Film. What is R.J. Anand versus Deluxe Film case? You know, R.J. Anand was a play director. A play director. What was the play regarding? The play was regarding a boy from Gujarati and a girl from Madrasi. A boy from Gujarati, girl from Madrasi. They both meet at Delhi. When they meet at Delhi during their study time, they fell in love. They wanted to marry. When they wanted to marry, the family disagree for the marriage. When the family disagree for the marriage, they say, family decide they still go ahead and marry, and they have a child. After that, the family comes back together and they have a happy ending. This was a play made by R.J. Anand. The Deluxe film producer who came and saw this movie, they said, hey, R.J. Anand, this is a wonderful movie, man. Play. Why can't we convert the set into the movie? And can you give us the copyright in this particular work for transforming the right of story into a movie? They asked. The R.J. Anand was also very happy. Yeah. He said, yes, we can do that. And in the due course of negotiation, somehow the connection loses. And one fine day, this person sees this particular movie called as New Delhi. That earlier R.J. Anand's play was Hum Hindustani, and this is New Delhi. What was there in New Delhi? There was a boy from Rajasthan and a girl from Bengali. A boy from Rajasthan and a girl from Bengal. They both meet at Delhi. They fall in love in Delhi. They they tell their parents. Parents disagree for the marriage. They still go ahead and marry. They have a child. Parents comes back. Now this is a movie which Deluxe Film came up with called as New Delhi. R.J. Anand see this movie and he files a suit against Deluxe Film stating that no, they have copied they have violated my copyright. Hence, I hold copyright. Okay. Now tell me, my dear sir and madam, is there a copyright infringement or not? Yes, quickly tell. Quickly, please. Some yes or no answers. Balchandra sir, Mamta ma'am, Madhu sir, Dhruva sir. Karibashweshwara Gowda sir, what about you? Around everyone says yes. Okay, let us see what court said. Sorry. Yeah. Let us see what court said. Court said that, sir, court said, one second, please. There can be no copyright in idea, as we already told. Idea of Ramayana, idea of extraction of oil, idea of drying the vegetables. No copyright in the idea. Subject matter, theme, plot, or history, Indian freedom struggle, assassination of Indira Gandhi, Operation Blue Star, or legendary facts. On all these subject matters, there is no copyright. For example, there was a Pulwama blast which happened. So how this Pulwama blast happened, how strike happened, etc., etc. If you make a movie out of it, there is no copyright for the idea, the subject matter, idea, subject matter, theme, plot. Okay. So then, sir, what if I make a movie out of it, Bhagat Singh? If I make a movie of Bhagat Singh, I don't get any copyright in it. And the copyright, they say, and violation of the copyright in such case is confined to the form, manner, arrangement, and expression of an idea. That means how in Ramayana, how you present, how you write your article, the form, the manner, the arrangement, and the expression of an idea by an author of a copyrighted work. That is important, right? So if you must have all known about yellow pages. What is this yellow pages? Yellow pages consist of what? Facts. What is a fact? The name of a person. It's a telephone directory consisting of what? Name of a person and the telephone number in the respective area, chronologically arranged and compiled. This is what you have done. Does yellow pages get copyright? Yes, yellow pages get copyright because though there is a fact in it, it is a certain amount of labor, effort which is went into it. Hence, the copyright is protected for the form, manner, and the arrangement of and the expression of an idea of an author. Okay. At the same time, when okay, sir, when the same idea is being developed, I also write an article on extraction of oil from a neem seed. You also write an article on extraction of oil from a neem seed. You also write an article on how to dry your vegetables and how effectively you can do it. I also write on the same one. Then when the same idea is being developed, there also Rajasthani and Bengali, Gujarati and Madrasi, when the same idea is being developed in a different manner, it is manifested that the soul what is the source being the common? What is the source being the common in Hum Hindustani and New Delhi? Answers, please. Movie source, the basis of the movie. Story. Yeah, madam. In the story, Mamta ma'am, in the story, what is that which is source being the, what is the source being the common? Not idea, no. Plot, no. Incident, no, no. Not incident, not idea. ಬೇಕಾ ಒಂದೇ ನಂದೊಂದೇ ನಾಗಾರ್ಜುನ್ ಕೆಳಗಿರ್ಬೇಕು ನೋಡಿ. Yes, tell me quickly. Character, no. Lovers from different states. Yes. Yes, Aruna madam. Very good. What is the source being the common in the both the movie? Two different people from a two different region meeting together is a source being the common. When the source being the common, two different people from two different region meeting at a single place, two states, very good. So in such circumstances, what is the similarities are bound to occur? What similarities are bound to occur? Sir and madam, quickly. What is that bound to occur situation? No willingness to love. No. Plot of the story. No, 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 no. What is the bound to occur situation? Very good, Aruna madam. Wonderful. Did you, by any chance, did you attend my previous class? Yes. The correct answer is when two different people meet at a single place, what is that bound to occur situation? Differences, cultural differences, linguistic differences, language differences, food differences are bound to occur situation. So those are bound to occur. It happens. Now, if I write an article on extraction of oil from a neem seed, you also write an article on extraction of a neem seed. We both have taken neem. When you crush, neem oil only should come, right? But the process of crushing which I made, where traditionally in my literature review, where people were able to extract 10 liters of oil, and in my new research, when I made a research study, I came up with 25 liters of extraction of oil from a neem seed. Then the literature review will be one and the same. The ideology will be the one and the same. The methodology may vary. So, in such circumstances, then the court should determine whether or not the similarities are fundamental or substantial aspect of the mode of expression adopted in the copyright are similar. Now tell me, sir, I have written article. Is my title of my article substantial portion? Yes or no? Is my introduction or abstract a substantial portion of my article? Oh shit, man.
Yeah, I think the session was quite interesting, and I think Vivek sir is having slightly the technical issues. We kindly request you to be patient. We will have Vivek sir join again. We are getting in touch with Vivek sir. He will be joining soon. Kindly hold on a few minutes and Vivek sir will join again.
Yes. Sorry for the interruption.
Yes, we have Vivek sir back in the
Yes.
session. Sir, everything is okay?
I feel everything is okay.
Okay, sir.
Yes.
So as per the schedule, I think we have about
I know.
five
Another
minutes
5
left.
minutes, I'll finish. Yes.
Yes, sir. All right. Thank you,
As per
sir.
the schedule only, I'll finish. Yes.
Yeah.
So the basic thumb rule which I was telling you is that what is a substantial portion in your article? Okay, sorry, I did not get the chat. I was not able to see the chat answers. I request everyone to kindly put up the chat answers in the chat box. Can you people tell me what is substantial portion in my article? Is the title substantial portion, abstract substantial portion, introduction is a substantial portion, or the usefulness of the study, hypothesis? What is your substantial portion of your article? Or the comparative study, the analytical study which you make, or the new methodology which you have brought in for increase in the yield of 15 liters to 25 liters of oil, is that substantial portion of your article? Or the conclusion is your substantial portion of article? What is your substantial portion of article? Mohan Priyas says hypothesis, no. Guest number 41 says methodology, no. Title, no. Guest number 18 says title, no. Jaswant says new methodology. Okay, to certain extent. Anyone else? Abstract, no. Anita ma'am, no. Anita Basu madam, no. Usefulness of the study, no. Please. Amrita madam say unique result. Very good, Amrita madam. Review of literature, no. Review of literature is not the substantial portion. Bhavani madam says the concept, no. Conclusion, but above conclusion is your result. And what is the new process which you adopted? Analysis. Mamta madam says analysis. To certain extent, the research. No, yes, sir. Pallavi madam, the whole thing is your research, madam. In your research, what is the substantial portion is the question. So the substantial portion of your work is, what do you say? Not the research design. No. The new methodology which you have brought out, or the new process for extraction of oil, and the result, how you are able to increase the capacity of yielding. The outcome, very good. Aruna madam says outcome. The findings, very good. Lakshmi madam. Aruna madam, Lakshmi madam, the findings. Sir, I did not copy his entire article, sir. I just took his, the result portion. I just took the methodology portion. That's all I have copied, sir. I have not taken the entire portion. There is among 100%, only 10% I can take. So among 10%, I have taken only 2 pages of the said 100 pages, which is the result portion, which is the finding portion, which is the outcome portion. Chaitra madam, objectives is not your substantial portion. Okay. No, this is for the sake of the copyright protection, I mean to say. Okay. The sources of data, exactly. So this is a substantial portion. So if at all, if someone you know what is a substantial portion of someone's content which you are taking, right? So it is, you need to be ensuring that did you copy the substantial portion or not. Okay. So likewise, there are various other methodologies or methods to get a copyright protection, which involves selection, judgment, and experience, skill, labor, and judgment. So these are the various other rulings. So that's all you need to keep in your mind, that whenever when you take someone's work or use someone's work, ensure that you are not going to take the substantial portion, rather understand the content and put it in your own idea and express it in your own form. It does not amount to a copyright infringement. Now under copyright, there are various kinds of work, as I said earlier: literary work, artistic work, dramatic work, musical work, etc. So now, what is that literary work comprises of? Because you're all very much concerned about this. So the books, the poems, novels, the question paper, even 5-line question paper you write, you are the owner of it. And the answers written by the students, it's also copyright protected. Abridgment, compilation, encyclopedia, data sheets, data manual, engineering manual, source code are all copyright protected. As I was telling you, that what is a bundle of rights which you get? Right to reproduce, issue copies, communication to public, translation of the work, adaptation of the work, inclusion in the sound recording and cinematographic work. Okay, these are the various rights you have. And now when you have these rights, there are certain, exception. Who is a owner and a author? Now, earlier when I had a debate with you all regarding the publisher, you have transferred all your rights to him. So now there is two things: owner and author. In case of literary work, artistic work, the person who writes, he is the author. But if you have transferred your right to a publisher, he becomes the owner. Okay. Composer. In case of music composition, composer. Artistic work, artist. Photography, photographer. Film and sound recording, producer. Okay. In case of newspaper, the newspaper chief editor will become a owner. Article person who writes the article becomes an author. In case of employee and employer, now you are all employed in a institution. Now if your institution says that anything literary work or any intellectual property outcome comes, it all belongs to the institution, then it becomes the owner is them, you are the author. Yes. Now there are certain exceptions for this copyright. What is that? Sir, I take some material, put it in my copyrighted work, in my work for my student circulation. Will it amount to a copyright infringement? No, it is an exception. So under what is the term of period of protection? Copyright, it is lifetime of an author plus 60 years in case of literary, artistic, musical work. In case of anonymous photography, sound recording, it is 60 years. Patent, 20 years. Design, 15 years. 10 plus 5 years extendable to 5 years. Then this one, sorry, I will not be able to tell about these case studies because of want of time. Yeah. So under section 52 of Indian Copyright Act 1957 says that copyright infringement, it does not amount to copyright infringement if you take someone's work for the purpose of research for a private study. That does not mean that, okay, fine, research I'm just taking. You have to give them appropriate citations, etc., etc. And for education purposes, if you are doing, which is in the due course of education, performance of a work in a course of education, then it's an exemption. Okay. So what is the process of registration? As I told you earlier, there is no any formality for registration, but if you register, it is a conclusive proof. For a literary work, it is just 500 rupees you have to pay and get it copyright registered. Once you have to file in the copyright registry, 30 days mandatory period. If there is an objection, then you have to clear the objection. If there is no objection, it will be granted. So this is a small process of registration, not much important. So that's all from my side. And thank you very much for everyone for their kind and patient hearing. I think this session I have also, I like that everyone have been actively participated. There is one question, sir. If my article is 5% plagiarized, then can I claim my article is 95% of my work original work under the copyright. 100% you can claim. You're absolutely correct. Absolutely correct, sir. So Shiv Kumar sir, you're absolutely right. So now the whole thing is these are the things about the copyright and its infringement, etc. area. This is what basically we have done this particular program. Next session, Mr. Nagarjun will speak about. So kindly listen to him also. If you have any questions, one or two, I can surely quickly take it up. And if no, then thank you very much to everyone. Yes, any questions? If not, to the host.
Thank you, sir, for taking us through the nuances of copyright laws. So any questions, we will take it up now. The audience, you can post your questions in the chat box. So we are getting questions.
Okay, what is the difference between bundle of rights and group of rights? Okay. There is no any strict definition provided under the law for bundle of rights or group of rights. Basically, we say copyright is having a group of rights or bundle of rights. That's all. It's just words. That's all. Nothing much difference under the law. Yes. Any other question?
Audience, you can post your questions. Sir, I think the session was very clear, so there are no more questions coming up. So thank you, sir, for the session. And we have understood how important the expression of our ideas is and how much important copyright is to our ideas. Thank you so much, sir, for these wonderful sessions.
Thank you very much.
Over to Evangeline, ma'am.
Thank you, sir, for that intellectual session on copyright, which is a powerful IP tool. And of course, you did touch upon its implications in research as well. Thank you so much. Yeah. So as we continue into our second session for the day by Mr. Nagarjun, I request Professor Bharati to introduce our speaker to the audience.
Good afternoon, everyone. R. Nagarjun, MG, is currently working as a project associate at Karnataka State Council for Science and Technology, IISc campus, Bangalore. Sir has completed his graduation in mechanical stream from KS Institute of Technology, Bangalore, and post-graduation in streams of manufacturing science and engineering. Sir has participated in many faculty development programs, workshops on IPRF. At Council, he was mentoring the bioenergy research and demonstration centers established by Karnataka State Bioenergy Development Board in all 30 districts in terms of technical and administrative roles. Sir has also coordinated the project of students program, kitchen garden development program, and the list goes on in its eclogues. Currently, Sir has assigned to coordinate the KSCST Patent Information Center and Technology and Innovation Support Center, TISC, WIPO. At PIC, he follows all the information, education, and communication activities of PIC. IP filing, establishment of IP cell, institutional policy making, and the other projects and programs of the Patent Information Center. We are pleased to have such an eminent personality among us. Without any further delay, I would like to call upon Nagarjun sir to take away the session and provide us the valuable inputs on IP commercialization.
Okay. Madam, thank you. Oh, can you able to hear me?
Yes, sir, we are able to hear you, sir.
Just let me put my PPT and go on with the class. Yeah, you can see the PPT, right?
It's loading, sir.
Yes, sir. Okay. So a lot many things has been told on intellectual property tools, everything and all. So in this particular session, we will deal with the commercialization aspects of the IP generated by us. Okay, so basically you all know that whenever an innovation, I mean, to identify the intellectual property, these are some of the important aspects. Like first, it comes through our ideas. Okay, so the concepts. Okay, to find a solution to any kind of a product, and basically with the marketing and all. So which product are, I mean, which are the products are demand at the current exist markets. Okay, so in all these aspects, to find some kind of solution, okay, you generate an idea to solve a particular problem. Okay, so to protect this, you have the IP tools. Okay, so these are all, you know, that is patents, trademarks, designs, plant varieties, copyrights, everything. Okay, so these are the varieties of IPRs where you can protect under in different category. Okay, so the idea generation by you can protect in these categories. And you also know this particular thing, that is the valuation and the subject matters of different type of IPRs, right? See, the patent is granted for novelty, its non-obviousness and industrial application. Copyright is for expression of idea, which Vivek has told very briefly. Okay, trademarks, where you are protected, the representation of a trade or a business can be protected. The aesthetical appeal of any product are can be protected under industrial designs. Okay, and you know this, the trade secrets, like where you not disclose the information, or you not share the information, or you won't register any IP, but still you are protecting your intellectual property. How? It's called as a trade secrets. Best example is the Coca-Cola formulation, where now the company has not disclosed this particular thing, and still they are successful in doing their business. Okay, and geographical indication, this is also one of the IP. Okay, so where it concentrates on a group of community, not on the individual. Okay, so GA basically it's a community right. Okay, so where it takes a separate type of commercialization, or it restricted to a particular geographical location. Okay, so rather other IPs like patents, copyright, trademarks, and trade secrets are all under one arena, and they are at the global level. Even GA also in the global level, but the way that the GA dealing with the existing other intellectual property is different. Okay, and you also know this particular terms of this particular intellectual property. Okay, that is in the designs 15 years you have, copyrights life of author plus 60 years. Okay, and generally the granting period for patents will be 2 to 3 years. Okay, and these are some of the statistics which has been discussed yesterday. Okay, so like in 2016-17 there were about 45,000 patents has been filed. Okay, and in 18-19 50,000 patents has been filed. There is a increase in patent application filing. Why? Okay, and now come to the next question, that is, there are many companies are lead in filing patent applications. Like for example, if you take TCS, Wipro, okay, Chandigarh University, of course now the companies along with the industry, I mean education, academic industries also in leading of patent filing. Okay, so but the corporate sector has a separate section of patent filing. They have separate R&D. Okay, so which were working on a particular application or technology. Okay, and they are going ahead with the protection of their rights. Okay, so in universities also with the policy, national policy 2006 national IPR policy. Okay, so now there is a change in filing or the way of looking the institutions also in the intellectual property criteria. Okay, so this is how you know this. Okay, so top research and development applicants and top universities. Okay, and come to this particular topic. This is very interesting now. Okay, so you also know that this is the intellectual property rights are territorial in nature. Like if you file in India, you will get protection only in India. If you file abroad, you're also protected under the abroad. Okay, so what is the need that we need to go and file in abroad? Okay, and for example, if you take this particular, okay, there are USA has filed a lot of application in India. 8,000 applications has been filed. Japan 3,000, China 2,000 approximately. They had filed in India. Why? What is the need? Okay, so can I have some chat answers? So why the countries, foreign countries, need to file patent applications in India? So what is the benefit that they get out of it? Like, for example, yesterday you had been discussed with the wickets, like the sensors based technology which has been used in the cricket system. Okay, so where the person from the Australia has filed in India. Why? What is the need? Can I have some chat answers? And someone could help me with that? So what is the need? Yes, any chat answers?
So do you want me to read out the answers on the chat box?
Yeah, you need to read out, madam. Otherwise,
Okay.
I couldn't able
All
to
right.
see the.
I'll do it.
Yes, madam.
Okay.
Please go ahead. Yeah. What is
Because
the
of
need? Yes.
yeah, because of territorial restriction, they need to file here.
Yes.
Protection of rights.
Protection. Okay. Done.
Due to huge market resources.
Yes, market resources. Yes, that is the major thing that we need to concentrate. Next, another points, madam.
Copyrights are territorial in nature.
Yeah. Okay.
To utilize the resources properly.
Yes.
Many Indians are spread over foreign countries.
Yes. Okay.
To increase reputation of nation.
Yes. Okay.
India is a big potential money source.
Oh, this is also, yeah. This is one of the important answer, because India is one of the money resources. How? See, lot of people see cricket here. Okay, so compared to other countries, India has a lot of population and more cricket fans here, and we always look. Okay, right. So the exact potential of the technology application is India. Okay, even though Australia, but the population country wise, it's limited. Okay, if you compare with India, we have lot of fans and lot of money generation for this particular technology in India. Okay, so like, however, for a match he get a 40 lakhs license. Okay, so that's where you need to, these countries, I mean these patent applications driven into India because of the large market segments. Okay, so now come to the company aspects, like most innovative companies, how they become most innovative. Because copying anything is very common in the sense, okay, so most of the things what we do, okay, so we have an objection, like somebody would steal our idea, or somebody should make some kind of alternate arrangement or product development for the existing system. Okay, so how you need to protect? So what are the major stages that we have? Okay, so now in this particular global market, okay, the Microsoft, Apple, IBM are lead in the patenting their innovation. So why they need to patent? Because they have a competitors all over the world. Okay, so otherwise if they don't patent or protected their innovations, then easily the other companies may steal. Even a lot of many cases has been going on, like Samsung and the Apple mobile case designs. Okay, so where a lot of cases has been filed by the Apple company suing Samsung that they have copied the industrial designs. Okay, so like that, there are a lot of infringement suits has been taken among the industries itself. So these are the lot of companies, I mean most innovative companies which has been recently quoted by Forbes, that they just observe how many patents has been filed and how many they have owned the patent rights. Okay, so if you take IBM, that is one of the lead patent filer and has a lot of IP on it. Okay, so in 2017 they had about 9,000 patents granted. Okay, so now overall about 6,000 patents has been on the name of IBM, which are lead in generation of IP and its protection. Okay, so the IBM is one of the important in this particular thing. So these are top 10 among the patent commercialization. Okay, so under the lead innovative manufacturers industries in the worldwide. Okay. Basically, what is the important for a company or organization to have an IP and to commercialize an IP? Okay, so firstly come to this, any IP which you generate has a business advantage. Okay, so or it should have a competitive advantage. For example, if you take the educational institutions itself, since you are working a lot and you can produce a lot of copyright articles, okay, research publications. Basically, most of the faculties are oriented with the publications, okay, rather than protecting under copyright or some other kind of IP, okay, they're more into the publications. Now, whether you just take another example, that Oxford is not depending upon the admissions of the candidates, okay, so they're not running the institution based upon the admission of the candidates. Rather, they are running our administration because of the IP generated with the existing system, okay. So a lot of publications has been copyrighted, and they are generating revenue from that particular. So on this particular competitive world, as we are faculty or the institutions should also think in that line to make the IP that generated by us to compete with the world, okay. So obviously you should have a market advantage, okay. So wherever your application are applicable in the current domain, okay, so you need to work in that particular direction, because many lab research, I mean, faculties are working in the labs where they can found some kind of a particle, but it cannot go to the market because of some kind of technology, lacking technology advancement, or also some kind of, there are no IP policy at all in the institutions, okay. So in this context, okay, to gain a commercial market, okay, so this is very important. Obviously, if you have any IP over you, okay, so you have a right, you have a right to license, you have a right to transfer any kind of thing. And another thing is, the major is evaluation, some kind of monetary benefit from the existing IP that you can generate, okay. So these are the important aspects that for an organization or a company which can look in these terms. That's the business advantage, marketing advantage, where you can have the license to sell, transfer, and to get some kind of monetary benefits is the most important. Yeah, now come to the factors to be considered for doing any commercialization, okay. So suppose example, assume the institutions, I mean the St. Francis. First question comes to is how you make commercialization, whether you alone can make commercialization of your products or institution can take rights over on it, okay. So in this particular criteria, the first question comes to our mind is who owns the IP, whether the university owns the IP or the faculty owns the IP, or any academic collaborated industry which has been made for commercialization owns the IP. Yeah, now comes to the first question. See, who owns for IP? Like assume the faculties of the same Francis College has filed 50 patent applications where 40 out of it granted. Now among the 40, okay, so who is the owner and who are the inventor here, okay. So whether the inventor alone is the owner of the application, or the university is the owner of the application. Can I have some chat answers? Is the university or yourself is the owner of your IP? Madam, you need to help with the chat answers. Yes.
Yes,
Who's
sir.
the owner?
Yeah.
Who's the owner? Whether
Once
it's
the answers are
university?
college, someone says college.
Yeah, good. Okay. See, as long as if you don't have any particular policy, since now, okay, so you are being employed by the institute, and you may be knowing, or you may be observed in the particular appointment, okay. So all the rights, okay, maybe there is a particular clause, especially in case of companies, okay. So we have a separate clause saying that all the IPs has been generated by the inventor is company's property, okay. So like that, if there is an statement saying that on your employment, okay, the intellectual property developed by the individual is the university property, then the owner is the university, okay. So if not, you don't have any such type of clauses, then you alone is the owner of this IP, okay. So next comes other factors for your IP generated, okay. So you need to consider the monetary factors, like how you need to commercialize. So what are the shares, okay. So like what is the shares between the existing university? For example, if you have the IP, I mean the faculty, okay. Now what is the percentage of the monetary benefits that you can get? So can I have some expectations from the faculty? Okay, so you had been commercialized the product, okay. So what is the percentage that you are wishing to get from your IP generation? What is the percentage? Yes, any answers?
Not yet, sir.
Okay, so okay, it's very simple. See, you have an IP.
50-50. Mr.
50.
Balachandra says 50-50.
So it's fair enough to give 50% to college and 50% to keep it up. Okay, fine, sir. Good. Okay.
Professor Maya says 50.
Okay, so now because since there are more faculties or some senior faculties are available, in the program, so that's why I'm saying 50-50 for fair dealing. Okay, so see, some of the engineering colleges which we have been working with the through the IP cell, okay, so for their IP policy preparation and all. Okay, so here this college, that is Gokte Institute of Technology, they had offered 80% to the faculty, to the inventor, and 20% to the institution. Okay, so in the similar way, there are a lot of institutions like REVA, 60-40, 60% to the inventor, 40% to the college. Okay, so like that, there are IP formulations, IP policy formulations, where you can also consider for this commercialization factor. And the rights, IP rights, who own the rights? Like, however you own the IP, okay, but rights will not be on your name. Okay, so you need to be consult with the college. Okay, so like, what is the rights that you have? Either you have partial rights on your invention, or you have full rights on your invention. And when it comes, okay, so if you have an agreement, or if you have some kind of association with the institution, then you need to follow with the university norms. Okay, so especially if you take the PhD thesis, okay, recently we had seen the notification in the PhD, the IP has been generated by the PhD thesis, or the candidate is the university property. Okay, so we have a separate clause on that. Okay, so now come to the type of IPs. Okay, especially with the type of IPs, you already should know. Okay, so under which category of that your idea or your technology or your system, okay, will be suit, so that you can make some kind of monetary benefit out of it, or some kind of commercialization out of it. Okay, so the technologies you need to identify where, with a particular type of IP, like whether it can go to patent. Okay, so for example, if you take, I have make a fabrication. Okay, fabrication in the sense, I have created a art. Okay, so basically it is a art. Okay, but I can imprint that particular art into a textile material, where it becomes an industrial design. Okay, so and now, compared to the copyright and industrial design, I earn more on the industrial design. Okay, so your idea of patenting system will be looking at the maximum economic benefits from the your invention. Okay, so like that, now I make with the industrial designs, rather than protecting under the copyright, I have a more advantage on protecting it under the industrial design. So now I'll go with the industrial designs. Like that, you need to identify what type under your idea can be suited particularly. Okay, certifications are IP comes now. Okay, so here we have a lot of IPs, you know that. Okay, but even though if you have, okay, so you need to note whether this is a registered IP or not. Okay, suppose if it is registered, and who are the owners, everything, the basic things you need to know. Suppose if it is not registered, then also the intellectual property, patent, or whatever it may be, it also can go for commercialization. Even it is under the examination. Okay, so it can go for commercialization. Okay, and commercial life of IP, okay, you know that the durations basically. Okay, so you need to identify the size of markets, where, because you have only 20 years of time. Okay, for patents you have only 20 years. So within 20 years you need to make some kind of IP generation it. Okay, so designs 15 years only. Okay, so like that, this also you need to consider for doing some kind of a business, because sometimes what will happen, many lot of patents, okay, industrial patents, if you take in some sources said that 50% of patents which has been filed, okay, so will not go for commercialization, because it become absolute, and many even they will publicize with the free of cost, but still people are not able to purchase. Okay, it's not that. Okay, but the technology at that particular instant is not needed for the industry or to the market. Okay, so that's why it is not like it's outdated technology, so it will happens like that. Okay, so you can also analyze that particular thing while doing commercialization, okay, because you need to estimate the expectation of life of a particular IP generated through you, okay, with all these technological factors also, okay. So assets with the further development in the same way, okay. So you need to update it with the technology, and you also have a note on what factors should be considered for this technology development, okay. So basically, especially when considered with the faculties where you do a small product in the lab, okay, if it is want to come to the market, okay, so you need to have some kind of a connection, okay, or some kind of a system where you can promote your technology to the land, right? Okay, so like for example, like the IP cells, the IP cells which has been established at your institute, okay, so where it can act as a facilitator to bring your lab technologies to the land. Okay. Now come to the market, and you absolutely want to know, or you should know, where is the business potential of your IP generation, okay, okay, and the area of application, everything you need to know. And basically the agreements, like what are the agreement, different kind of agreements you need to follow with the IP, okay, and actions on the infringements, okay. So many times it will happen like this, okay. So even if you have some kind of IP and which is legally protect everything, but somehow it has been infringed by some other person. Look, so in that circumstances, what are the factors to be considered for retaining your IP on you? Okay, so these are some of the important factors that you need to be developed. Now, see, after considering all these factors, now what you need to do is, okay, so you need to sell or do some kind of commercialization out of it. So how you can do? We have majorly 4 types, that is the assignments, that is licensing, or that is the partnerships. Okay, so these are the major types of IP commercialization systems or methods, simply you can say. And there is no exact system of IP commercialization, okay. So this is a formal basic terminologies which are used in the IP commercialization. But however, there is no a set of systematic that you need to go along with this way to get IP commercialization. There's nothing like that. Just identify some kind of a partner and you go ahead with the different kind of assignments, okay. So now in this particular mode, the assignments, okay, so that means you are assigning your IP to a particular person. For example, A, I am the owner, B, some kind of a company, okay. So now you are assigning your particular technology to the particular, company B, where you transfer completely the rights to the B. Okay, so here you don't have any further rights on your IP. Okay, so you will get a lump sum amount. For example, if you take the MTR, okay, so MTR has been sold for a Norway company, okay, that is Orkla. That the company which has a Norwegian company. You know how much they had paid for MTR? How much? Have some chat answers. What is the revenue has been generated by selling this complete MTR foodstuffs to the Okra Norwegian company, foodstuff company? Any answers? Rough guess. What could be the value? Lakhs, crore.
5 crores.
5
23
crores.
billion.
23 billion, yes.
2 answers, sir, as of
Okay,
now.
fine. Okay, see, it has been sold to 353 crores. Okay, 80 millions. 80 millions has been given to MTR, okay, for their complete transfer. That is, they have assigned complete MTR to the company, to the other foodstuff company, that is Norwegian company. Okay, so in this particular assignment, the person who owns the IP is called as assigner, and the person who takes the IP is called as assignee. Okay, so now here you will just transfer the complete rights. Okay, so there will be immediate cash flow, and there will be a large benefits to you, like you will just take lump sum amount and you will go back. Okay, and further you don't have any, you need not stress on a particular IP, that is, you no need to follow up it up further, any responsibility, or you take any management on IP. Okay, because you have assigned the chapter close. Okay, so which means you have given complete rights to the person, and he is free to do whatever he wants, like he want to continue with the existing terms. Now come to the second system of commercialization, that is licensing. Okay, so this licensing is, we already know that. Okay, like in simple words we can say that like house rent. Okay, where the owner is giving rent house to you, where you pay a monthly of 5,000 or 10,000 depending upon the infrastructure or the agreement. Okay, the license, I mean agreement which you had been, rent agreement you had been signed. Okay, so here the person with having the IP is called as a licensee. Okay, licensor. The person who takes that particular is called as a licensee. Okay, so here there is a transfer of the intellectual property between one person to the other person. Okay, so by some terms and conditions. Okay, so where you can give your rights for a particular person on with some terms and conditions. Okay, so basically here there are different types of ownership, and we should note that here you are not entirely transferring your IP. Okay, you just transfer a bit of your IP, because earlier in the assignments you transfer complete thing to the person, but here you will have the right over it. Okay, but you will give a rent. Okay, in terms of a rent to a particular person. Okay, so in this particular case we have different terminologies called in licensing, out licensing, and cross licensing. So in licensing in the sense, okay, so you deal with a single particular person. For example, a company with A and company with B. A which having the this is a licensor, okay, which having the IP, so you give license to the B only. Okay, there is only one-to-one communication. Okay, so out licensing in the sense you will give multiple license to a different person, simple in a simple way. Okay, and cross licensing in the sense here you pledge your IPs together. Okay, like A and B, the companies A and B have both two patents, for example. Okay, so where this A company uses the B company's two patents on their name, and this B company uses A patents on their name, and they do the business. Okay, where there is no monetary implications here, but the pledging of intellectual properties together. And there are furthermore important terminologies in the licensing. Firstly, exclusive license, where you will give only for a particular person for a particular time. Okay, where even the licensee can also, like the person who assigns the IP to the person, okay, he is also not able to use further in this particular extent. Like for example, the simple case of the faculty itself, where you write on the publication once you apply for any journal. Okay, there you I mean all the rights are reserved for the publisher, where you lost your right. Okay, and if you want to study the same paper again, you need to pay to him. Okay, so this is what the exclusive licensing means. All right, now come to the sole licensing. These are different terminologies. Sole licensing in the sense, okay, where both the parties, like the licensee and the licensor, can use their IPs, okay, with a single direction. Now, non-exclusive licensing. So here, both the parties, or like the licensor and the licensee also, okay, can license or can negotiate further to license with it for further companies. Okay, there is no exclusive with a particular technology. So here what they do give assigned, I mean they do license with some terms and conditions for other industries also. Okay, so other option we have, that is optional agreement. Okay, so this is the law. Many industries do this particular agreement. Here there will be a time limit. Okay, so for example, if you take a technology, okay, so since it is a R&D project, okay, so you need more years to come for particular applications. Okay, for initial beginning, okay, for initial beginning there will be, for example, the total complete project about 10 years. Okay, so for after 10 years you can able to analyze the essence of the particular technology and the returns from it, and the overall product development or the efficacy of the particular technology after 10 years. But in the beginning, okay, so you do what you do, you make an agreement for initial limit period to test whether this technology will be feasible after 10 years or not. Okay, so like that you will make a simple agreements. They depend upon the mutual understanding. And evaluation of technology in the same way how I said now. So in the similar way, you evaluate technology based upon the some terms and conditions. and obviously there is no commitments in this particular optional agreement. Okay, so basically because suppose if you take the university background, okay, so where the universities don't have a exact platform for commercialization or any guarantee results over the existing R&D development that they're doing. Okay, and basically the research oriented in the universities or with the faculty's interest. Okay, so not with the public interest. Okay, or with the problem interest. Most of the research that they develop with their self-interest. Okay, so in this criteria, okay, so if any industry found very important optional here, okay, they do some kind of a optional agreement, and with seeing with the further extension, okay, so they will seek what are the changes need to be done. Okay, then they will make a proper agreement, and they'll go with the generation of this IP. And now comes to the mode of, I mean, the partnership. This is one of the important type, okay, where both the parties, okay, with suppose example, assume A and B is having both IPs. Okay, so they are responsible equally for the generation of IP and also loss generated through that IP itself. Okay, so both the parties have a risks. Okay, and both are engaged equally in development of their IPs. Hero Honda. Okay, so earlier it was a company, single partnership company. Okay, so where they had been filed a lot of designs, protection, patent protection. Both the companies have equal rights. Now Hero becomes separate and Honda becomes separate. Now only Honda Motorcycles Limited, okay, and Hero Motorcycles Limited. Okay, so we have two separate entities now. Okay, they have break their partnerships and they had been individually forms now. Okay, so like that. In the partnerships, the IPs which has been generated or to be developed shares equal majority of royalty. Okay, and maybe there will be a funded collaborations, unfunded collaborations. Okay, unfunded in the sense is simple, like they just pledge their IPs. Okay, so a lot of incubations will be there in the partnerships. Okay, so basically the institutions, how they need to develop. Okay, so because a lot of institutions have incubations. Okay, I believe in Bangalore itself we see about 10 to 15 incubation centers where the students can develop some kind of centers, and he can associate with industry, and also further he can also this is how the basic commercialization has been taken in the IP field. Now here one of the simple concepts we have, that is spin off. Okay, so where this is a management of intellectual property rights, okay, with an university. Okay, within the university, for example, okay, a university has set up a R&D center. Okay, so basically to focus on some kind of problems. Now after the establishment of R&D, the scientists under R&D working in the university, they had developed a product. Okay, now these products need to be come out to the market, so they will set up a simple type of associations where they can turn the R&D center into a company. Okay, they can create this R&D center to company and to come to the market. Okay, so a simple basic understanding if you take. Okay, so spin-off in the sense, most of the universities will choose this particular way. They fund the technologies. Okay, they own the IP and they do form the companies and they do the business. Okay, so if you take a startup, okay, in the simple way, it is created by outside the university. Okay, anybody can do a startup, right? Technologies, they can take any type of technology associated with the university or not with the university. Okay, and it is financed by any other person or self-financed. But here the spin-off, okay, the simple technology, I mean, is financed by the university itself. So these are some of the important terms that is used in IP commercialization. Now come to the key terms which a person or a faculty need to understand during this particular commercialization process. Okay, so maybe these are all we already know this particular thing, but however just to note, to have a particular understanding is very essential for you to, if you found any IP on your name, and if you want to do commercialization, this type of words or this type of terms used will be benefit to you in your particular IP commercialization in future. Okay, so basically you need to understand here the grant of rights. Okay, like what is exclusive for me, non-exclusive. Okay, so which rights are owned by me, which are not owned by me. Okay, right to sub-license, because many patent applications, what we do is, okay, so we give particular license to a person, we restrict that fellow to not further license to any other, because it's a single license or exclusive license that I have given to a particular person. Okay, so in this particular context, you also need to understand, okay, so right to sub license, whether I have or not. Okay, so you need to make a small difference, or you need to make a clause for the statements also. And duration, you need to understand, like for example, if you take the engagement of consultants in the institution, okay, so they will give 5 years of agreement or 2 years of agreement. Okay, so confidentiality, this is very, very important even in the industries and also in the academics. Okay, so in your employment contract, okay, so they will mention, and they say that you should maintain the confidentiality here. Okay, for especially with the government departments and all, we do sign this particular confidentiality agreement where we do not allowed to share any kind of information or letters or any proposals with the other institutions, okay, or with the public. Okay, so the confidentiality be taken consideration in the commercialization aspects. Limitations, we should know very clear about our limitations, where with the positions, okay, with the IP technology. Okay, so we should know where I need to go, the geographical locations. Okay, so the technical, for example, if you take what you take, okay, fine, you take a simple GI product itself, Mysore sandal soap. See, Mysore sandal soap is only in Karnataka, that too Mysore region. Okay, so we have they produce the Mysore sandal soap. Okay, the Kaveri Emporium, I believe. Okay, they had complete rights over it because they had filed the registrations, everything. And if you produce this particular soap in a particular region, that is especially with the Mysore region or Bangalore, if you take the Bangalore is the most preferable, because you have the manufacturing plants here itself. Okay, so here the protection is given only for a particular location. Okay, so the same thing cannot be manufactured in the Kerala or any other states in the country, because you need to take permission with this particular owners, and then you need to reproduce. Like that, there will be a limitation of the geography, and also with the technical and commercial fields. Okay, so compensation in the sense, like what is the royalty that I may get with the commercialization of this technology. Okay, so how much I will be benefited, the institution will be benefited. Okay, and these are some of the terms. And ownership and over improvements. Okay, so this is particularly with the cutting edge technologies. Okay, like the softwares. Okay, we have a lot of softwares that has been the 5G, 4G. Okay, a simple mobile phones, you have more than 2,000 odd patents on it. Okay, so like that, you have further, see, even for a 3 months duration gap, you have a new design, new generation, new tablet. Okay, so it's coming in the market. Okay, so now it's a matter that who is the owner of this particular products. Okay, and obviously the warranty or the technical limitations. Okay, like the duration in the same way of the agreements and all those things. See, these are the key terms which the people need to study, or if they are going for any kind of agreement or any kind of bond writing or some kind of thing. So these are the important parameters that you need to identify. Okay, so for your IP, parallelly also in your contract employment also, you just go through your contract employments, you just study this particular thing. Okay, so most of 4 to 5 words, which has been represented here, will be appear on your paper. Okay, so you need to know this particular terms. Now come to the innovation radar, like how I can commercialize, like assigning, licensing, partnership, everything, that's all okay. So here also we have some kind of a strategy need to be developed in this IP platform. Okay, because IP itself is a strategy. Okay, so there is no particular way to develop, to follow up, but this is how you need to plan for your organizations. For example, if you take this particular companies, that is Amazon, Sabyasachi, okay, Tata, Flipkart, ID Fresh Foods, Paytm, okay, Uber, Jio, will they, Of course, they also do some patents. Or they are only working with their patents? No. Okay. So let us take this particular example here. See, Uber is a company which is a car-owned company. So here, Uber acquired, okay, so a lot of patents, and they make business model out of it. Like for example, if you take, see, they have taken 4 patents from Google, okay, about 88 patents, 80 and intellectual property, okay. So they had taken intellectual property with different firms and acquired together, okay, and started a business. Okay, so this is how you need to have a strategy of developing your idea to commercialization. You need to focus on this also. Now come to the faculties. Okay, this is a simple case study where you already know that this is patents, intellectual property rights are territorial in nature. Okay, so here one of the concept is that if I have a patent in US, okay, I cannot go patent the same in India also, because it is already prior art and I cannot get a patent on it. Can I do a business out of it? Yes or no? If suppose I have a patent, US patent, okay, I mean I have a US patent in US, but I don't have a patent in India. But can I do some kind of a business activity with that particular patent in India or not? Because you cannot go with the patent filing because it is already prior art available, hence you won't get a patent. But to use that particular patent in India, do you have a right or not? My question. Yes or no?
Mr. Balachandra says no.
No. Okay. So how you say that? Because see, this is territorial right. If you protect in India, you will also get protection in India. How you stop without having any IP protection in India? Okay. So a similar case study here. See, this is a US patent which has been filed in the US. Okay. So a piezoelectric shoe charger. See, this was identified by a person in Kenya that is called Mutuo. What he did, he just take the patent application, he study everything. Okay, so the same concept he has been utilized, and he developed the shoe in Kenya. Okay, so this basically works with the piezoelectric system. Okay, now this piezoelectric shoes are selling in Kenya. Okay, so they're in the market, and this particular he cannot acquire the US market, but rather he can do business in his own country. Okay, so this is one of the simple example where you can also explore the already patented invention, okay, which are suited to your locally, so you can extract that particular patents and do the business. Okay, yeah. So this is a similar way how we evolved. Okay, so need to identify the key partners. Okay, and you need to identify the value proposition, how much it should, and a customer relationship be there. Okay, so like what, how, in the sense you need to do with the business. Okay, so how the manufacture should be done. Okay, so every aspect you need to identify, and you should focus on a particular area. Now a simple example not with the same case. Okay, so like how people can explore the commercialization and how do they do the trade business. You already know this ID fresh food, right? They have the Keralian fellows have started with a simple batter selling the batter. Okay, so they had come up with this particular vada making mission, vada making equipment, a simple vada making equipment which has been where if you pour this particular batter to the bowl, okay, it will exactly circular, and you will get a crispy vada there. Okay, so the system that they had patented. Okay, so sorry, I have missed that particular patent application. Okay, for this particular vada making knob. Okay, so they had got a patent. Now no company can acquire that particular thing. Okay, if they want, they need to design some other kind of technologies, or they need to take the license, or they need to take, or the ID fresh food need to assign that particular right to the particular company. Okay, so what they did with all this IP protection, they are doing a very much good business. Okay, and especially with the current fast IP technology, not IP, IT technology especially. Okay, where people are very worried about this night workings and all those things. Okay, just simply 2 minutes Maggi we have now. Upma vada, something it has been in the market, 2 minutes upma. Okay, so there are a lot of similar products which has been come up in the market. Why? Because of the necessity, and parallelly the way that they develop with the particular trademarks, everything and all. Okay, so it attracts a lot of market in the system. Okay, so this the IPR policy 2016 gives a detailed information regarding the total IPR arena in the country. Okay, so which facilitates most of the things very easier. Okay, so in 2016 it has been come. So with the new revised IPR policy, we are able to conducting lot of webinars on IP. Okay, so and basically it focuses on the commercialization also, where it facilitate the IPR policy gives a facilitations where, okay, to creative and encourage in the public domains and private sectors. Okay, so facilitations like incubations, like MSMEs are giving lot of incubation startups to the colleges, universities. Okay, and create an industry academic interface. Even the NRDC, okay, a simple best example, National Research Corporation, okay, NRDC, where they are also, they're earlier also they're in the venture. Okay, so recently they had filed, they had commercialized the product developed by National Innovation Ocean Sciences. Okay, it's basically oceanographic innovation has been given. The technology has been transferred to a company. Okay, so you can just see and go through the NRDC website, where you can find a lot of commercial technologies has been the educational institutions which they had filed an IP. Okay, so that has been transferred with this medium. Okay, so where the industry academy interaction has been creating with the policy. And obviously, to promote collaborative IP generation and commercialization, okay, so efforts has been taken in the R&D institutes, and a lot of funding agencies are there now. Okay, so now the universities can look up with the associations with the different industries. Okay, so they can make their own kind of rules, regulations, everything to form a setup. Since an IP cell has been established in this particular university, so you can frame an IP policy, and you can have some kind of associate with some kind of industries for the IP creation that you develop, and you can also do the commercialization. Okay, so with this I conclude. If at all if you have any queries, I can happy to answer. I'll conclude my session now. Yeah, thank you for having me.
Thank you, sir, for explaining to us in detail the basic factors of IP commercialization and the process involved with it. Now we will take up few questions. I request the audience to post your questions in the chat box. So we already have 2 questions from Shivakumar sir. The first question is there any provision in the Patent Act to the innovator who work in research firm to own the ownership of his invention?
Okay, just a second. Where it is? Wherein I have a mutual agreement with inventor on the grounds of research funding. That is Shivakumar SM, right? So that's his question, right?
Yes, sir. He has posted 2-3 questions.
Yeah. Okay. Oh, here I found, madam. Yes, thank you. Yeah, is there any provision in Patent Act to innovator who work in research firm to own the ownership of invention? Yeah, we have the provisions of inventor. Okay, so like what percentage that can, not exactly with the percentage, but there is some provision has been given to inventor. Okay, so it has been specified in the Patent Acts. Okay, so you need to bifurcate that. See who owns the patent. So that's why in the patent form itself. Okay, so you will fill this particular thing. Name of the applicant, name of the inventor. Okay, so the applicant is the owner of your application. Okay, so name of the inventor is you. For example, if you take Shivakumar, so you are the inventor. The name of the applicant will be your college. So the college will own the complete ownership on your patent. Okay, so and you internally can make. Okay, so like suppose in case if you granted some kind of IP, you generate some kind of IP revenue out of your IP. Okay, so you can make an internal agreement between the institution and you. That is the best system is the IP policy. If you don't have any IP policy like that, so you can create some kind of agreement between you, saying that 60-20 or something. they can keep it with the institution and yourself. That kind of provision can be there. And is there, okay, fine. Own the ownership, yes, yeah, ownership, it is clearly understood. That is, if you want the complete ownership, then you can you need to get a no objection certificate. Okay, it's simply you need to get a no objection from the university, because in the contract there will be a clause. Okay, so like that, all the IPs has been generated under the university, and it will be, the owner will be university. So for that particular clause, you need to get an NOC. Then if you apply for this particular complete ownership of your patent on your name. Okay, yeah. So can I file an IPR on behalf of inventor and can claim the ownership rights? No, you can't do that. Okay, but if you you can make, generally generally how it happens in the sense, okay, so we have 4 to 5 inventors for one application, we have that. Okay, so here normally 1 or 2 fellows has the complete idea of the particular, but however you can add 2 to 3 persons on behalf of you. Okay, so this will happen, you can do that. Okay, but the ownership you need to bifurcate, like you need to, if you make a small agreement, then it will be very good for you in your any future consultancies like this. Okay, yeah, wherein I have a mutual agreement with the inventor on the grounds of research funding. Yeah, you can do that based upon the research fundings. Also you can make a particular statement saying that, okay, this much you can keep, and this much revenue has been taken by myself. So with respective bonds, okay, so what we call that, agreements, okay, with the necessary affidavits, everything and all, you can make that particular statement clear. Okay, can we extend the time of the patent protection? Say I already have 10 years, can I extend this to time? See, the patent, once it is granted, it is for 20 years. Okay, so further it cannot be extended. The protection comes to you from the date of filing, or even if you get a patent. For example, if you take in 2014, a faculty from Ramaya University has filed an application. Okay, so in 2014 he filed, he got patent granted in 2021. Okay, so which is a recent one we have seen. Now the total protection already 6 years gone. Okay, so the rest 14 years, what the time he left, he need to identify the respective market and respective investors for his technology. Okay, so or a particular incubation you need to identify, you need to go ahead with the commercialization. Okay, because he already lost 6 years, but you have a right from the date of filing. From 2014 he has the right, but the time left is already only 14 years. Okay, so it cannot be extended. 20 years, 20 years, that's all. Can a company in USA which has filed the patent in US use the same patent in selling its products in India? Yeah, it can use. Okay, it can sell the particular products in India also, but there should be, like, if the similar kind of any patents which are not in India, then no objections will come there. Obviously they have a good market, no problem for them. If suppose a similar kind of patent has been filed by India in Indian territory, then obviously somebody can sue against them, saying that you had copied my invention. Some kind of sue takes place. Okay, so there will be a what is called proceedings will be taken in front of court. I don't know what will happen. Okay, because both the companies need to prove whose the company product is that. Okay, the genuine product, whether the Indian company or the USA company. Okay, so based upon their date of filing, IP protection, the court will decide whether they need to continue with their business in India or not. Yeah, yeah, they can. USA can do the business. Yes. Can you list out funding agency? Okay, see, funding agency in the sense, I can give one institute right now. Okay, so even KCST also is working in this session, because we have the TISC, Technology Innovation Support Center, where we are also working on commercialization of technologies. Like if the people had, and also we are working with the WIPO, Word Intellectual Property Rights, where the innovations that you develop in the institution or on your name faculties, okay, it can be projected on the global website. That is called as the WIPO match, where if the people really want your technology, they will approach to us or they will approach to you directly, depend upon the mutual agreement. Okay, so where if the industry wants your technology, they can take through the KCST association like that. So in similar way, the NRDC now, they are already in this domain a lot of years. Okay, so they only take, they only fund your innovation for patent. Okay, until from the filing till the grant and also till the commercialization, the NRDC will support you, and also they will take back some kind of returns out of it. Okay, so that's with the mutual understanding. Yes. So this is NRDC, and the future maybe KCST also working in the direction. In the future, maybe you can get KCST as one of the fund sources for in this particular IP field, I believe. Okay, it's not exactly, but maybe we can hoping to do that. Yeah, special codes in the sense, normally we have special advocates in this area, like IP firms we have, like banana IP. Okay, so like that IP firms, they will take particular cases like this, and it will be discussed in the same codes itself. And also you can see that IPAB, that is yes, Vivek, the appellate board. Yeah.
So as you said, the special courts in Bangalore, CCH 10, that is court hall number 10, is a specific court for dealing with respect to intellectual property disputes. That is one thing. Second one, we have intellectual property appellant board, which is IPAB. Whenever there is your application for patent has been rejected, or your application for copyright has been rejected, or your trademark registration is rejected, or any such appeal on your IPRs, you can go for an appeal before IPAB. But recently, because of Supreme Court, one of its decision or the government decision, IPAB was withdrawn, and the powers of appeal from the IP office was given to the High Court, respective High Courts. Okay, as of now, in High Courts, there is a court called as commercial courts. Okay, because to fast track the cases, there is a special commercial courts where the matters related to intellectual property rights or commerce related aspect, the matter will be referred to the commercial courts, and the commercial courts will decide on the matters. Okay, yes. So that's a special court in Bangalore. City Civil Court, court hall number 10 is for IP disputes cases. Likewise, we have IPAB, which is a tribunal to deal with. Now IPAB is being removed. High Court itself is considered. In High Court, there is a special benches called as commercial courts. Under Commercial Courts Act, the cases will be referred to the commercial courts. Yes. That's it. Anything else, Nagarjun?
No, faculties need to be said that. Anything else from their side?
There are no more questions, sir. Thank you for your responses. And thank you, sir, for such an informative session loaded with facts and figures and giving us a holistic picture of ID commercialization. Thank you so much, sir. I request Nagarjun. Yes, sir. Thank you, sir. I request Nagarjun ma'am to take over.
Yes, thank you, ma'am. And once again, thank you, sir, for enlightening our minds on IP commercialization. Thank you. As we've come to the end of the FTP, Day 2, I request Professor Bharati to propose the vote of thanks.
As we have come to the end of Day 2, it's a privilege to thank the people who have made it a success. The technical sessions 3 and 4 were very much informative and knowledgeable. I thank Mr. Vivekanand Sagar for providing such a vast information on copyright and its implications in research. I would place my sincere gratitude to Nagarjuna sir for rendering such an informative and enriching talk on IP commercialization, patents, and licensing. Thank you, sir, for being with us today. I thank the audience who took active participation during the sessions. Dear participants, the link is posted in the chat box and we will also be shared in the WhatsApp group. Kindly fill it. On day 3 of our faculty development program, we will have discussion on the topic National Education Policy 2020 and blended learning. Thank you and hope to meet you again tomorrow. Have a nice evening ahead.